Good afternoon. We're waiting for the participants to load. Thank you for attending and thank you for your patience.
And Robert, I see we're up to about almost 500 attendees. I think we're about halfway there. It might take a few minutes to load. And I'm hoping they're patient while we get going. Robert, as they're loading, I just want to remind all of our viewers that we are recording this and it will be rebroadcasted or available at a later time.
Absolutely. Thank you, Jeanette. And it looks like we have a few people are trickling in. We're at over 700 now. Give another few seconds and then we will begin our program. All right, good afternoon. Welcome to Virtual Hearings, a discussion of statewide best practices for local government and land use hearings. Today's program is presented by the Florida Bar's Environmental and Land Use Law section, Real Property and Probate and Trust Law section, and the City, County, and Local Government Law section, a collaboration between the three, along with our partners over at the Florida chapter of the American Planning Association. My name is Robert Volpe. I'm an attorney at Hopping Green & Sams in Tallahassee, and today I'm excited to serve as one of the moderators for today's panel. Due to the overwhelming demand for this webinar, we've decided to record, and that recording will be available online after the live webinar, along with additional materials that may be discussed during the course. You are encouraged to submit questions through the Q&A function. We've set aside time at the end of the program to answer as many of your questions as possible. If we do not get to the questions, if there are certain specific topics that are repeated, the panelists will be available to answer some of those by email or in some materials after the broadcast. Also, following the seminar, you must self-report your CLE credits by visiting the Florida Bar member portal, that is floridabar.org, and entering the course number for this seminar, which is 3944. Again, that course number is 3944. The Florida chapter of the APA is also offering AICP Law CM credit for this webinar. As I mentioned, this webinar is presented by three of the membership sections. If you've not already done so, I would encourage you to join those three sections. If your practice involves local government land use hearings, the Environmental and Land Use Law section, the Real Property and Probate and Trust Law section, and the City, County, Local Government Law section all offer resources, including continuing education seminars such as this free seminar, exclusive access to other resources such as the Environmental and Land Use Law Treatise, news updates, and networking events across the state. You can update your membership and join one of these sections also through the Florida Bar membership portal. With that, I hope you enjoy the program and thank you again for joining us today. At this time, I would like to introduce my co-moderator, Jeanette Smith. Jeanette is the city attorney for the city of Margate, Florida. She's been practicing in various government positions in city, county, and state level across the state. And prior to her legal career, she was also involved in information technology at companies such as UPS and Nova Southeastern University. So Jeanette brings both the perspective of being the city attorney for the city of Margate, as well as her past experience in information technology. So thank you, Jeanette, for co-moderating, and I'll pass the torch to you.
Thank you so much, Robert. I sincerely appreciate and want to thank all of the sections of the Florida Bar for putting this webinar together so quickly. This is a very hot topic that has been, I think, out there for all of the sections to consider. I do want to give a special thank you, at least from Broward County, to Sam Gorin with Gorin Sheriff and Duty in Ezerl. He was the first in my county to have a quasi-judicial hearing. He has given me extensive feedback and information, and I thank him very much, as well as Tom Ansbro, who's about to have his first quasi-judicial hearing with the city of Dania Beach. This is uncharted times for all of us, and we're certainly doing the best we can in this environment while not losing the preservation and the sanctity of the process. At this time, I would certainly like to introduce our panelists who have a wealth of information. I'm proud to say that we did get panelists on both the developer and applicant side, as well as city, county, local government. Our first panelist is going to be, in order of last name, is Nikki C. Day. Nikki is a shareholder and practice group leader at Brian Miller Olive, PA, where her primary practice includes representing city, county, and state government entities in all manners of legal matters, including complex litigation. Next, I'd like to introduce Patrick. Patrick Turowski has over 20 years of experience in real estate, land use, environmental, governmental, administrative litigation, appeals, and title insurance law. Robert K. Lincoln, who we affectionately call Lincoln, concentrates his practice in the area of land use law and local government litigation. He is certified by the Florida Bar in city, county, and local government law. Next, I'd like to introduce the city attorney for the city of Miami, Victoria Mendez. She is a board certified city, county, local government by city, county, local government law by the Florida Bar. She joined the office in Miami in 2004, she joined the office in 2004 as a municipal prosecutor, brings a wealth of information on this subject matter. Next, I'd like to introduce Erin Tilton. Erin is an attorney at Hopping Green and Sam's, where she represents clients before the courts, state agencies, and elected bodies on land use and real estate development issues. Again, we have an excellent panel at the end of this seminar. You are welcome to read the bios of all of our panelists. We have extensive bios that will be available for each of you. Sherry, if we can go to the virtual housekeeping, I just want to let our audience know the kind of rules of engagement. That the virtual housekeeping matters is all participants will be muted. They are muted. Only the panelists will be able to present throughout this presentation. Any questions that you have should be sent in via the Q&A function on your screen. I understand some of you are already raising your hand, and I apologize. We're not going to be able to open up the floor for our participants, given the amount of participants we have on this webinar and a short period of time to get through the material. Towards the end of the webinar, panelists will address the questions and answers submitted as time permits. And then at the very end of the seminar, we're going to have final thoughts from each of our panelists provided in chronological order. I believe this really gives the housekeeping matters, and it's time to get into the material. So I'd like to ask my very first question, and that question will go to Mr. Lincoln, Robert Lincoln. And I'd like to ask you, Lincoln, what are the essential requirements, elements of a quasi-judicial hearing? Can you give us a broad perspective as we open up this seminar?
Thank you, yes. So let's start out with some of the basics. A quasi-judicial hearing is a hearing at which procedural due process protections have to be afforded. Sometimes that's by statute, sometimes that's by common law. We won't go in today to a discussion of why they're quasi-judicial. Critical elements are procedural due process, and that a quasi-judicial hearing has to be based on the record made at the hearing. This will go to a lot of our discussion about how to implement this. Local quasi-judicial government hearings in the local government context, they include rezonings, special exceptions, variances, conditional use approvals, site plan approvals in a lot of locations. code enforcement, all those other kinds of approvals that generally occur before a board or a special magistrate. We're mostly talking about land use as our examples here. School boards, other local government entities also hold quasi-judicial hearings, sometimes often around contracting or disciplinary or personnel kinds of functions. The basic aspects of a quasi-judicial hearing, the due process requirements, are notice and an opportunity to be heard at the hearing. With respect to notice, there's a case that we all studied in law school, Mullane versus Hanover Trust. The basic elements of notice are that it has to be sufficient under the circumstances to give interested parties the information that they need to participate in the proceedings at enough time for them to meaningfully participate in the proceedings. With respect to the actual procedures, the parties to a local land use hearing are the applicant and the local government staff. And if the local government has adopted an ordinance to do so, affected persons, neighbors or other people who might be recognized as aggrieved or affected persons. I'm flagging this because it's optional from a due process standpoint. Parties in a quasi-judicial hearing must have the right to present evidence, cross-examine witnesses, and be informed of all the facts on which the board acts. For a person who is not a party, their due process rights are much more limited, and it is essentially a right to notice of the proceedings and the right to attend, and for limited participation, again, depending on statute or the local ordinances. There are some statutes in Florida that affect the procedures that are used in quasi-judicial hearings at the local level. For rezonings, there are special notice and hearing requirements for the city and county commissions by statute. There's a recent statute that covers, there's different ones for cities and counties that imposes time limits for the review of development approvals, including the hearing process, and now requires quasi-judicial hearings to end in a written decision. There are the sunshine laws that impose some meeting requirements that will apply to quasi-judicial hearings as well. Though I do want to note that the required mandatory public participation statute, 286-0114, does not apply to quasi-judicial hearings, again, unless the local government chooses to. Beyond that, Florida's a home rule state. Every one of the 67 counties and 473, I think, or 4 municipalities in the state of Florida has the right to adopt in their charter or in ordinances, regulate or resolutions, the actual procedures that will govern decisions in that and procedures in that local government. And that's kind of the context for a lot of what we're going to talk about today, which is how do local governments adopt under those powers, adopt proceedings to have virtual quasi-judicial hearings. And on that, I will turn it back.
Well, thank you so much, Lincoln. I certainly appreciate the overview. And for the next question, I would like this to go to Nikki Day based on what you're hearing with Mr. Lincoln's overview. From a government perspective, what are the fundamental differences between virtual hearings and in-person hearings in the context of framework of these types of meetings?
Thank you so much, Jeanette, and thank you all for attending this afternoon. The basic framework for these hearings, as just discussed by Mr. Lincoln, is that interested persons be given a reasonable notice and reasonable opportunity to be heard, which, as he highlighted, includes the reasonable opportunity to present evidence and cross-examine witnesses. Now, formal rules of evidence don't apply like in traditional court proceedings, but instead they're governed by general concepts and principles of fairness. Well, the fundamental difference between a virtual quasi-judicial hearing and an in-person quasi-judicial hearing from a government perspective is really in determining two things. First, whether to proceed with a particular hearing at this time, and second, how to provide for each of these elements while balancing the public health, safety, and welfare, and also the welfare of its staff and employees during the COVID-19 pandemic. Now, traditionally, the government focus on the first issue, whether to proceed, was far more limited. This was likely because it was premised on an assumption that there are physical locations in the jurisdiction that it will be safe to gather large groups of people. In this climate, that has really fundamentally changed. Now governments are faced with a much more in-depth and intricate upfront analysis of whether it can or should proceed with a particular hearing. This includes considering things like, what is the government interest in proceeding with the virtual hearing at this time, as opposed to waiting through the phases of reopenings? For code enforcement hearings, the answer to this question may take into account the nature or gravity of an alleged violation or potential threats to the general public health, safety, and welfare. For development order hearings, which is the bulk of what we'll be talking about today, the answer to this question may also take into account statutory or other deadlines that the government faces. Governments are also faced with considering the potential complexity of the hearing in this new era. This includes considering things like whether the hearing is going to involve a traditional cattle call type proceeding, which often invites large amounts of people who are often unrepresented and usually involves pretty limited prior coordination among the parties. Is the subject matter controversial and therefore expected to draw a large amount of people? On the other hand, are there any other potentials to streamline the proceeding by working with applicants or others? So given the complexity as well as the potential state or local orders that may be restricting movement within an individual jurisdiction, the second fundamental difference, how each of these required elements can be provided, will likely vary from community to community. This is not only because the Florida Constitution provides for home rule, as Mr. Lincoln just discussed, and as such, there may be differences in the tools, resources, and procedures that have been determined to be best for a particular community, but also because the entire framework that we're talking about here is based on a standard of reasonableness. And what's reasonable in one community may be different in another. In some communities, difficulties with addressing this second issue, how to provide for each of the required elements reasonably, may end up driving the determination of whether to proceed at all. These are questions and decision points that prior to COVID-19 were in many instances a given, or at least well established by historical practices and procedures. But these are also the very decision points that present the fundamental difference from the government perspective in moving away from the way we've always done it and determining whether and how to proceed in this new era. And I'll leave it to Victoria if she wants to provide any additional comments on what she's seeing down in the city of Miami.
Thank you, Nikki. Those were all super important points that we as government attorneys have to really take into account, everything having to do with access and the ability to provide due process to the applicants and to the participants involved. So all your points are very valid.
I'd like to turn a similar question to Mr. Kurchowski. Patrick, from an applicant private party standpoint, what are the fundamental differences that you consider when going into a virtual hearing setting, and how do you approach this virtual hearing setting differently?
Yeah, thanks, Robert, and some really good information from the previous three on kind of the structure and the rules. So I'm going to kind of answer this question in a more practical sense, not disregarding what the underlying law and you heard Robert Lincoln mention the procedural due process and the record. Those are all things that are, vastly important. But from a practical standpoint, and I'm actually going through a few of these virtual quasi-judicial hearings right now, and it's almost a sense of what is the playing field, what are the rules here for how this is going to be held. And you could equate it to if you were going to a normal quasi-judicial hearing in a jurisdiction you've never been in before. You know, how are things set up? How are questions asked? What's the interaction? I joke sometimes that if I go to a commission meeting or a board meeting and I'm having to stand up in front of the board and answer substantive questions at a public hearing, I've probably not done a lot of my job already. So the interaction with the elected officials, the client interaction, sometimes we all know that if you have a very important project or maybe even a controversial project, it can be very beneficial to have the property owner in the room to show interest and to show value in the project and not just, you know, quote unquote hired gun. So what are all those rules? How's that going to work? How am I going to interact with the board? How am I going to respond to either questions from the board or information brought up by a third party, whether that's the public or in general or a specific neighboring property owner? And then how might I guide, you know, my client's interaction and participation in the process? So, you know, for this particular question, for me in representing an applicant or a private party is really what are the practical implications of participating in this kind of new environment? And I'm sure we're going to continue to talk about it. And it seems from my experience that almost every local government is doing it a little bit different based on their comfort level, based on their capabilities, based on what they think their interpretation of the law may be. So it's not just one playing field. Everybody's doing this a little bit different, and we're finding that some local governments are not comfortable doing it at all. And we'll certainly talk about that as well.
Great, thank you. And Aaron, you come from a similar perspective. Do you have anything to add or to what Patrick just said?
Yeah, and thank you, Robert. I think Patrick did a pretty good job of covering, you know, kind of what those considerations would look like from the applicant perspective. I would just add that I think, you know, communicating with the local government and kind of understanding what resources they have available to them in this setting is really important, and getting a little bit creative in certain ways. You know, if Patrick had mentioned that sometimes you want your client to maybe meet with the elected officials ahead of an issue coming to their board or whatever it might be. And, you know, we in a few jurisdictions that commissioners are willing to do that over a Zoom meeting, for example, one-on-one, obviously, not to create any sunshine law violations, which I know Vicki will get into in a little bit, but just understanding what resources are available and being a little bit creative in how you approach those interactions is important at this juncture.
Great, thank you.
Thank you so much, Aaron. I think you really help us get into our next question. And I know Victoria with the city of Miami, you know, the Tri-County is not opening right now. We're still under our executive orders, but to dovetail on what Aaron was saying, what are the considerations regarding Florida Sunshine Law, the Public Records Act? How should those issues be addressed for these virtual meetings?
Thank you, Jeanette. Basically, what we need to realize is that even though we're in this virtual meeting world, we need to conduct business as close to what we've always done to provide access to all that have had access in the past. And that's what we really need to concentrate on in dealing with these virtual meetings, and especially in quasi-judicial matters. I like the way that Patrick analogized things as we're dealing as if we're acting in different jurisdictions. And it's very important to talk with your city attorneys, your staff at each city to see how they're going to move forward, because we are doing things slightly different in every jurisdiction, but the main focus is that we are able to provide access and maintain the same level of services that we have previously, just in a virtual platform. So as we all know, Governor DeSantis allowed for virtual meetings in his Order 20-69 and the follow-up order that extended this in 20-112, but he only suspended quorum requirements. All other, for virtual, to allow for the virtual meetings, but all other sunshine laws, public records laws, everything that we do on a daily basis, all that is still intact. So we have to make sure that in everything we do, we comply with Florida Statute 119 and 286 with regard to access and open government and complying with our sunshine laws. And we also have to make sure that we comply with everything else that Robert Lincoln started talking about at the beginning with regard to all types of hearings and quasi-judicial hearings, the way we pass resolutions and ordinances, notice, none of that has been suspended. So that's why we have our developer attorneys that are very anxious to move forward and are getting very frustrated with government because government is saying, okay, we really need to make sure that we continue giving access to government as we have in the past. So that's why, unfortunately, we're still going a little slowly with regard to quasi-judicial hearings. And now we're seeing the uptick in the requests for quasi-judicial hearings, and some have already been started. I know that the city of Miami has had about 5 virtual meetings, but we still haven't had our first quasi-judicial meeting, which we should have at the end of the month. So we need to make sure that we're in compliance with all of our other laws, because just because quorum is suspended doesn't mean that we just throw everything else out the window. So quasi-judicial, those are the types of hearings that normally get appealed or go to court. When was the last time you heard about a strictly legislative item or a grant award being appealed or being brought into a court setting? You really only remember the quasi-judicial matters. So those which require much more public participation, much more notice, are the ones that government attorneys are most nervous about. So we know that sunshine requires meetings to be open to the public, notice of the meeting, and minutes to be taken, and none of that should change for a virtual meeting, none of it. And that's why we need to make sure that the processes are still followed. I recommend that we overshare, that you work really close with your media and communications people at the city to make sure that you're able to work with your notices, that all your notices are up to date and amended in order to take into account these new virtual meeting platforms. The city of Miami has several notices, and we're going to share those with you to make sure that you post on your social media, you work with your bloggers, the friendly and the unfriendly ones, to make sure that as many people out there are able to know that you're having a meeting, because the last thing you want is for no one to know about your virtual meeting, especially your quasi-judicial ones, and then try to invalidate your meeting afterwards, which could be the worst thing that could happen to anyone, because you spend so much time on these quasi-judicial meetings, especially, for then to someone say that it's void ab initio because the notice and due process and proper proceedings weren't followed. That is why the developers' attorneys need to work hand in hand with the government attorneys to make sure that everything is followed. Make sure that your code provisions are also followed, because sometimes you have in your code or in your charter even more restrictions that you didn't think about. And now more than ever, you have to make sure that you're dotting your I's and crossing your T's. Pursuant to 166.041 Florida statute, you have to make sure that you notice your resolutions and your ordinances. That can't stop just because we're in this new virtual platform. Now more than ever, you have to make sure that your notice is up to date. Let's be honest, a meeting that's not publicly noticed is not in the sunshine and could get your elected officials, your board members, everyone into trouble. and it could then be, as I said, just null and void. So we want to make sure that all the work and all the effort we put into these meetings actually comply with Florida statutes. So the best way is for everyone to work together to make sure that this happens. And that's why in defense of our government attorneys, we've been so nervous about this and making sure that everything is up to par before we go through with our meetings. The other thing is limiting points of access from the public perspective pursuant to 286.011 is problematic. So you need to make sure that you solve this problem by giving more access, by televising, by making sure that you're streaming live, by working with your IT departments to make sure that a platform like Zoom allows the proper access. You also need to make sure that you're meeting all your ADA requirements, that everyone that needs assistance is able to reach out to local government and they're able to get access. Because as you know, there's also in the same section of 286, if you're noticed that you're not providing access, then that could limit your meeting and you may have to reset your meeting. So these are things that are paramount to being able to hold a proper meeting. And every opportunity that you're able to overshare, do it as a government attorney. And for developer attorneys that have much more access to other venues of communication, please work with your government to try and be as helpful so that your clients are able to get the best, most noticed meeting as possible. So those are some of the points that I wanted to share. Obviously, a lot of the local governments are setting up quasi-judicial rules in order to follow. I know that the city of Coral Gables, I know that certain firms have already set these up. I know that down here in Miami-Dade County, all the city attorneys are trying to work together, give each other the best practices. We're working with the Florida League of Cities and posting all of our quasi-judicial rules and notices in order to help everyone be able to have the best virtual quasi-judicial and regular meetings as possible.
Great, thank you. That was lots of good pointers and perspective. Aaron, I want to turn this a similar question to you, seeing as that we have a broad spectrum in Florida of size of counties, size of municipal governments, location, size of staff, things like that. How do you, as an attorney for an applicant or typically coordinate with the government staff and attorneys through the application process? And has that changed in this virtual setting? And how do you approach that? And how do you change your approach to be able to address all of the things that Victoria just mentioned?
Sure, thank you, Robert. And I think you'll find that from the private sector perspective, it's really not terribly different from what you just heard Victoria mention. I think that just goes to the fact that really on this issue, the public and private interests are aligned in making sure that the process is correct and that we're moving forward with a hearing that is truly defensible and doesn't infringe on anyone's due process rights. So as the applicant's attorney, or for some of the other professionals that may be listening into this broadcast, if you're the agent for the applicant, it would be the same thing applies. Coordinating with the local government in this new sort of remote environment we're in is almost even more important because of the many new obstacles that are presented by holding quasi-judicial hearings remotely. You've heard from a few public sector attorneys this morning, kind of given some details about how their jurisdictions are handling those hearings and the types of resources that they have available to them. And I think Victoria and Patrick both mentioned this briefly, but there's very little at this stage, if any, uniformity, frankly, in the way that local governments are handling remote hearings. There certainly are local governments with the resources and technology to be able to conduct remote hearings very much in the same way that they conduct their in-person hearings, where there are real-time opportunities for public participation and interaction in those ways. But there are also local governments who are taking the approach of implementing more of a hybrid of both an in-person hearing using social distancing guidelines to the extent that they can, and also offering an option for public participation remotely. There are local governments that are conducting hearings based solely on evidence and public comment that's submitted prior to the hearing. And then there are also local governments who have decided we're just not going to hold any hearings right now, and until it's safe to do so in person, we're going to ask for a continuance on those. So I think in order to develop your strategy for your hearing, you really need to understand the process that your local government jurisdiction has in place in order to be prepared for any unique obstacles that process may present. Just a couple of examples. If you're in a jurisdiction that doesn't allow you to submit evidence in real time, you really need to consider the use of things like pre-filed testimony from expert witnesses to be certain that your record has everything in it that you will need in the event of an appeal. If your jurisdiction allows for remote participation only, meaning no one is present in the hearing room, or if it allows for some sort of hybrid, but you happen to have a witness that isn't comfortable for one reason or another being physically present in that hearing room, you need to think about how your witnesses are going to be sworn in order to provide their testimony. And it's frankly probably a good idea, given that the record could be a hybrid of things that are submitted electronically and in person, that you start off each of your witnesses by their direct testimony by asking them if they have been sworn, so that you have that on the record. Regardless of the process, you need to be prepared to address the adequacy of the notice, as Victoria touched upon, and also whether those public comments that were received in advance of the hearing were included in the record. And I'm going to steal an idea from Kim Kopp in City of Destin for a second, because I saw her use this in a hearing this past week. But a good idea would be to have your clerk available to be sworn in and actually testify on the record as to the notice procedures that were followed and how the clerk went through the process of making sure that public comment was received and entered into the record. So I think that was a really great idea that she had and implemented very well. And I guess I just don't think it can be overstated here that both the applicant and the local government interests are aligned here, and making sure that at the end of the day, the process that we come up with and the ultimate outcome of that hearing is going to be defensible and have guaranteed due process for everyone involved. I mean, no one here wants to put in the time, the money, and the effort to conduct a remote hearing just to have it overturned on a procedural issue. The elected officials need to be comfortable from a political perspective that moving forward with a remote hearing doesn't infringe on their citizens' rights. So sometimes we're not even necessarily talking about what is constitutionally required. We may be talking about what is politically palpable. So again, I can't emphasize enough that it's critical to work with the local governments to ensure that that process is adequate. And at the end of the day, if as the attorney for the applicant, you're not truly comfortable that the process that's in place is defensible, you need to be ready to advise your client about what the risks are of proceeding with that process and be able to weigh them against the impact of frankly what could be an uncertain delay in being able to move a project forward.
Great, thank you. And Robert, I'll pitch this question to you now. Procedural due process has been mentioned several times. What are some pitfalls there? What's the constitutional standard, and how do we address procedural due process?
Yeah, there is a level, and this was referenced before, at which reasonableness and fairness, which is unfortunately subjective in a lot of cases, are the guiding constitutional limits on procedural due process. That said, there are a few things that we can point to. First, failing to follow your own adopted procedures that are procedures for due process purposes can be a violation of due process. So if you have, for example, a process in place for today for recognizing third parties as affected persons and giving them party status. And that's in your ordinances today, but somehow when you go to create virtual meetings, that disappears. That could be a procedural due process problem. The same is true with a lot of other kinds of processes that might be in place. And in some jurisdictions, this might go to the swearing of witnesses issues. Some jurisdictions have those things built into their charter or their ordinances, not only that it will happen, but particular modes for how witnesses are going to be sworn. I mean, in Sarasota County, there's a card that you sign, and the fact that you're going to sign this card is what's referenced in the ordinance. And so adopting for Sarasota County, if they're going to have a virtual proceeding and anybody who speaks has to have signed that card, they're either going to have an amendatory writing that provides an alternative, or provide a way to adapt that particular process to the virtual meeting. And there's lots of ways you could do that. People could sign them and send them in. You could create a place to virtually sign those online and have them automatically submitted. And again, home rule and innovation, there may be dozens of different ways to solve that issue that different local governments may adopt and that would be constitutionally appropriate. The most important thing is to recognize that you have to have a process, and that whatever you do today in this emergency can't violate what your charter or other ordinances say unless you adopt an emergency order or some other governing writing to handle it. The same kind of thing is true in particular with the record. There are not any statewide standards for what the record is or how it is compiled. And this again varies from jurisdiction to jurisdiction, but virtual meetings create several different problems for the record and due process. One of those is that if the materials that are going to be in the record are not available ahead of time, then any third party that might end up with a due process claim might be able to go in and claim that they didn't have enough notice of what the issues were to participate fairly. Most local governments handle this by, in one way or another, making the board packet available electronically or physically at some time ahead of the hearing. But the notice of the hearing doesn't necessarily include a reference to that. But people know how to do it today. And there may or may not be a written procedure governing that. I think that one of the things in going to virtual meetings that's going to be important is to absolutely make sure that everybody who is going to receive notice of the hearing also knows where to get the materials. And that would be the staff report, the application, any other things that are submitted, and that those are available in enough time for a third party to prepare for the hearing. And for the third party to have a way to submit evidence, particularly if there's going to be issues about how new documents or information can be accepted at the hearing. So these things just all need to be thought out. And I think that moving to the virtual kinds of meetings, because it'll be harder to fix things on the fly, having written procedures, and maybe much more detailed written procedures than a lot of local governments typically have, may be an important component of making sure that it works and that it complies with due process for protecting the record, for participation. You know, the evidence is supposed to be taken by sworn testimony, but there's a lot of room in the common law for how that can be done. I would say that if you're seriously concerned about it, submitting something in writing, an oath or affirmation would be sufficient. I do believe that you can mass swear over video if it's done by an appropriate official. I do think that this is one of those areas where if your clerk or whoever is going to be serving as the clerk is not a notary, or is not otherwise an officer in front of whom oaths can be taken, that you might want to arrange to have a court reporter there, because a court reporter will be a notary and is authorized to take oaths. That might be a way to fix that. With all of these things, I'll point out to one other issue. Stuff happens, and these are going to be messy, and things that happen during these hearings may create possibilities of due process problems. One of the best ways to fix that or address it is to make sure that everybody knows that if something gets messed up and it's affecting someone's ability to participate, that continuing the hearing, to give a chance to resolve that and bring it back, and then, whether it's an issue of, I never got to see these documents, I need to see them in order to respond to them. I never knew about this witness. Our ability to cross-examine just got blown up because the witness disappeared after, got cut off technologically after testifying. All of those kinds of things could be due process problems that could be solved by continuing the hearing, bringing it back later, and correcting it. And making sure that you make that work, I think, is going to be one of the keys to having everything work. And again, I think that does mean that before, after, and during those hearings, the government attorney, whoever is serving as clerk to the board, and whoever is the presiding officer have to be in sync and communicating about how all of these different things are going to be handled, on the fly, when everybody's under pressure because you're on video and you don't know how everything else is going to work.
Absolutely.
Thank you so much, Robert. Definitely, when we're dealing with technology, the mantra is, if anything can go wrong, it probably will. So we certainly appreciate that explanation. Taking from there, I'd like to give a question to Nikki Day, and it's similar to, relating to what was just being said by Robert. What are the specific considerations for the notice of a virtual hearing? What about the distribution of the information prior to the hearing? How to submit documents? We know a lot of times in these meetings, the witnesses, we get to meet them for the first time as the hearing's happening in person. So what considerations are you thinking in the virtual environment when we're dealing with the documents, the witnesses' distribution of information? I'd like to hear your thoughts.
Thank you, Jeanette. So the first consideration that comes to my mind for notice specific to a hearing conducted virtually is to address the core requirements of Section 120.54, subsection 5B2 of Florida statutes. I'll say that one more time in case anyone's listening. It's subsection reference 120, section 5.4, 5B2. The governor's order suspending any state level quorum or physical location requirement, which most of us are familiar with as Executive Order 2069, and encouraging that local governments meet virtually as a result of the COVID-19 pandemic, specifically references and incorporates this section of Chapter 120. I do want to note for those participants who may not yet be aware that Executive Order number 2069 was originally set to expire on Friday, May 8th, but that has been extended by Executive Order number 112. The statute that it was incorporated into the governor's order, though, remains, and it's a part of the Administrative Procedures Act. It directs uniform rules to be provided for state agencies to conduct public meetings electronically. But the implementing regulations of that section actually include certain specific notice requirements that if a local government is traveling under the authority of the governor's order to meet virtually would need to be addressed. And there are 5 main things. 1, that the notice include the date, time, and specific web address or other means of electronic access. 2, that the notice include information on how to access and participate in the meeting. As we've discussed, based on the different platforms or methods of procedures that are used by an individual government pursuant to their home rule authority, that may differ, but the notice should address how to access and how individuals can participate in the meeting. The notice must also include an address and telephone number where interested persons may write or call for additional information on how to participate. Fourth, the notice must include an address and designated person to whom written or other physical evidence intended to be offered at the hearing is to be provided. And finally, if a government is proceeding with a type of quasi-virtual, quasi-physical hearing, the notice must also include addresses of those physical access points, if any are offered. So at first, the first thing that has to be addressed are those core requirements, because they are implemented into and integrated into the governor's order. But in addition to those core requirements of 120.54, some additional considerations for notice have been highlighted by some of the comments that have already been made by the panelists so far, including whether to include a deadline by which written or other physical evidence must be submitted to the government in advance in order to be considered. This is something that we're familiar with conceptually in other civil proceedings and court proceedings, but is one that is not always implemented or used in quasi-judicial complex simply because of the relaxed evidentiary standards or other unique aspects of the quasi-judicial proceeding that is a little bit different from civil court proceedings. But considering having a deadline for the submission of evidence can help the parties not only in logistical aspects of how that information may be able to be presented during the hearing, but can also help the parties in determining other tools or resources that may be needed in advance. It'll help the parties in determine how to distribute that information that Mr. Lincoln was talking about a moment ago prior to the hearing. If you don't know what you need to distribute, it can be difficult to determine how you need to distribute it or what it constitutes a reasonable distribution of that information prior to the hearing. Some additional considerations for the notice would include whether to include a deadline by which parties and witnesses need to be identified in advance. Again, that's not something that you may commonly see in a pure sunshine law notice of a quasi-judicial hearing, but it's something that could be considered in this time when there's more coordination required. That identification could also consider the locations or technological capabilities of the parties and witnesses. This can help with the parties in determining not only the relative complexity of the hearing that I talked about in the beginning of my comments with regard to the biggest fundamental concerns for government actors during this time, but also would assist in some of the other figuring out the logistics that some others have raised about the administration of oaths and swearing in witnesses. So most of us are familiar with the Florida Supreme Court order that has been entered and as it was extended as late as yesterday. And it provides for the administration of oaths and swearing in of witnesses electronically. But part of what the order does not describe or define is one, its applicability to non-judicial proceedings, such as quasi-judicial proceedings, but also how or what the methods should be utilized for positively identifying the individual witnesses. If a function of the notice for the quasi-judicial hearing is to identify the parties and witnesses that intend to speak in advance, then that can provide an additional opportunity for your clerk or whoever is going to be administering the oath to be comfortable with the individual that they are positively identifying by electronic means. Some final considerations. Remember, as Victoria explained, the Sunshine Law notice provisions are not suspended. So notices of quasi-judicial hearings should continue to address all of those Sunshine Law requirements, many of which are included in Chapter 286, but include things such as notice regarding a party's responsibility to create a record and preserve a verbatim record if one is desired. and the processes for persons with disabilities to request reasonable accommodations. And finally, this really isn't a specific consideration for the content of the notice, but with regard to notice in general, and some people have alluded to this as a recommended best practice, local government should consider adopting uniform procedures to be used consistently for notice of its quasi-judicial hearings, particularly virtual quasi-judicial hearings. And those uniform procedures will not only be able to ensure that quasi-judicial hearings within the jurisdiction are noticed consistently, but also can address the specific situation faced by that community, including for our Tri-County South Florida members of the city, county, local government law bar down there, whether there are any state orders continuing to restrict the movements in your community. And every sunshine law meeting and every quasi-judicial hearing notice should also consider the resources available to its residents and constituents. Those are always going to vary by community to community. It's always a factual consideration that has to be considered with regard to reasonableness. And so adopting those uniform procedures, addressing the specific factual situation faced by that entity would also be something that local governments should consider.
Thank you so much, Nikki. As we all know, and I'm sure, everyone on this call from different areas, every city, county, we are different. We do have home rule. And some of us allow participation from the public, and certain cities and they don't allow that public participation. So I'd like to ask that question to Victoria, is what are the considerations related to public participation? How should those be handled? If you have a meeting that is normally open to the public and allowing them to participate in this virtual environment, if we dovetail that and try to limit that, maybe that is going to leave a bad feeling for others who normally participate. I'd like to hear your thoughts on that.
Thank you, Jeanette. Well, basically, the city of Miami is one of those jurisdictions that allows public participation for everything. So right now in the middle of the pandemic is not the time to rewrite our laws and ordinances in order to limit that. I mean, obviously you can, but I don't know that right now is the time to be able to say that pursuant to 286-0114, that you could just limit all your quasi-judicial meetings to just the applicant and an intervener. Though you can totally do that pursuant to law, if that hasn't been your practice, I think right now in the middle of a pandemic should not be the time that you're amending it. But that is one option to make yourselves a cleaner record. In the city of Miami, our public participants, which are pretty much anybody from the public, also has to be sworn in. So another reason why we have been a little hesitant as to the availability of quasi-judicial meetings is for that reason, because we're trying to figure out the best solution to be able to swear everybody in appropriately to allow for the public participation. So even though we have allowed for public participation in our regular virtual meetings by many methods, we have our live streaming, we have YouTube live streaming, we have our television channel 77, we have Periscope. So we still allow people to come to City Hall. City Hall is open, our clerk is there, so we have that also point of access issue covered just in case. But the main thing is that in the quasi-judicial aspect, then you have to make sure that you follow state statute plus your own ordinances. And we actually have a very strict public participation ordinance that we have to deal with. And that has made things a little more difficult. And that's why for our virtual meetings, it's going to be, for the quasi-judicial aspect of it, is going to be that hybrid quasi-virtual, if that exists. But basically, we're going to have our clerk available to swear in people. And applicants can come to City Hall. We'll obviously follow all our social distancing guidelines. We'll make sure that everybody's safe to be present, but that may be part of the solution in order to give everybody the ability to come and be sworn in. Obviously, developers' attorneys also have the ability, as Robert mentioned and Aaron mentioned, that you'll be able to swear in people with a court reporter from a different location. And that can limit a lot of the problems with the swearing in of your witnesses or different pre-sworn in situations, because you'll have someone who is able to swear in, is able to confirm that someone is sworn in, and you can actually record that. So that would be consistent with obviously the Supreme Court's order. But as Nikki mentioned, it doesn't totally guarantee, because we as administrative bodies in these quasi-judicial meetings are not mentioned in those specific Supreme Court orders. So we're doing the best we can in order to allow for the public participation and to be able to be compliant with Florida statute. The City of Miami allows for public participation in many forms, and some of the suggested forms, and it is in our notice, which is we allow for telephone call-ins, live call-ins, where we call back the participants, pre-recorded telephone calls, pre-recorded videos, obviously attending in person, following social distancing guidelines. We do also allow for video submissions. So we're trying to allow for over public participation. I'm not sure that our developers' attorneys will be thrilled with all of that participation, but that is what we have at the City of Miami right now. And every local government needs to make sure that based on their rules, they're allowing for all this public comment. For those that don't have those rules, it will be a much easier process to have these virtual meetings, just because the public participation is limited, but still compliant with state statute and your local laws.
Great, thank you. This has been touched on a little bit, and actually I want to mention to all the participants, thank you for your questions. We have just a ton of great questions coming in, so I look forward to answering some of those, and we have some good repeat questions, so we're working through that process and we will be answering those shortly. One that's come up several times, and I want to direct this to you, Patrick. Timing is always a consideration and a concern when you're going through the development process. How are projects staying on track amid this switch to virtual hearings, and how do you handle that?
Yeah, thanks, Robert, and I appreciate the attendees asking that question. I mean, the reality is, right now that projects are not staying on track. They're at least a couple of months behind, if not more, and some of them continue to face the uncertainty of the delays that this pandemic is causing and the adjustment and the response to it. And so if you think about that, just in Florida alone, let's say for sake of discussion, 100 municipalities, 100 jurisdictions with multiple projects in each, you're talking about hundreds of millions of dollars in economic impact and jobs that are being impacted by what we're all navigating. And again, not dismissing the law and the rigid guidelines that we're all bound to follow, but you heard Robert mention it, and you heard Victoria mention it. Robert mentioned the word messy, and Victoria mentioned we're doing the best we can. I've practiced on both sides of the table. I've represented local governments, and obviously I've represented private entities. And quasi-judicial hearings are rarely perfect in a perfect world, and we're not in that perfect world. So, from my perspective, is how can a lawyer help navigate this process we're in? working in conjunction with the given local government, providing feedback. I think you've done enough here. I think we're covered. Or providing, some avenues for improvement. If you see something that you think has not been addressed or covered, that needs to be brought up, and we'll talk later about the long-term impact of that. But it's been my effort the last couple of months to try to get things through the process. And some of that, it has nothing to do with quasi-judicial hearings. It has to do with the fact that people are working remotely and maybe they can't access, large plans to approve and to review. Maybe documents are getting hung up in, the ether sphere, or whatever it is. We're all dealing with that. I mean, we've put so much effort into just getting this program off the ground and all the technological aspects of it. And so, getting a project approved has been slowed down. There's no doubt about it. And folks are being impacted by that on both sides of the table. And so, the concern is, how do you get something approved? How do you get it through this kind of new process and still comply with the law and do the best we can and deal with the messiness of it? And that can go from, the quasi-judicial hearing all the way to just getting the fire marshal to sign off on your site plan, and then being able to access those documents. And so I think the role of an attorney just kind of needs to be flexible and shiftable to respond to what we're going through. I'll just give it, a quick story. I don't want to take up a whole bunch of time, but I had a local government official who was uncomfortable with the process say to me, I think we're just not going to put controversial projects on our agendas for a while. And that's just not acceptable. That's not how this process works. And it's not how it should be implemented, even in response to what we're all going through. These projects need to get through the process. They need to get approved. And we need to just do the best we can with what we've been given. I have seen instances where private attorneys are kind of pointing out some issues in writing, so that, it's part of an email. Hey, I think, this may be problematic. But at the same time, I've seen some folks reacting in the way of, you can't hold up my project just because you can't, figure out what it is that needs to be done. We need to work on this together so that these projects can get approved. And I think everybody plays a role in that, from the applicant side to the local government side.
Thank you. I agree that everyone plays a role, and that's, I think, something that has been repeated in this conversation, and that it is a process that we're learning and developing and learning as we go through this process. So it's even, there could be some side benefits here where both sides of the table realize that there are better ways to do things and more efficient ways to address some of these issues that we encounter all the time, whether it's public records or public participation or noticing. I mean, everybody's taking a harder look at what they're doing and how they're doing it. And so hopefully there's some long-term improvements that will add to the overall efficiency of how we do this. Absolutely. I think that Victoria mentioned all the things that they're doing at the City of Miami to implement the processes they already had in place, and to also even go above and beyond those processes. And I think that across the board and across the state, governments are looking hard at their processes. You mentioned outside of the quasi-judicial process, just an example here in Tallahassee, they've implemented virtual building inspections, which has worked out very well from what I've been told. So there are lessons to be learned across the board from this, the way we're going through this process. I want to turn to another question that we've had several different iterations of this question come in, but Mr. Lincoln, to you, another set of stakeholders in this process is the non-parties, the third parties, the affected persons. What are their concerns in this process, and how can those be handled, and what are local governments doing to address those concerns?
I think we've got to split it into two different questions. If a local government recognizes that neighbors or other third parties can be formally recognized as aggrieved or adversely affected persons and have party status through that in their regular hearings, I think that there has to be a process here that allows them to, that type of a person to meaningfully know about what it's going to take for them to do it, follow the process for getting that recognition and participating as fully as a party in the process. And that means that they would have all those Jennings v. Dade County rights, including cross-examination and whatever rights you gave to anyone else. I'll note that it's very divided in the state as to what local governments are doing that and what local governments are following the alternative, which is the Carillon residential case, which basically says the parties are the local government and the applicant, and everybody else is a participant because it's a public hearing, but essentially they have no other kind of due process rights other than to know the hearing is going on and to be able to have their 3 minutes. And in fact, even that is kind of a function of that public hearing process. I would note that under 286-0114, the public participation sunshine law, quasi-judicial hearings are accepted. And you don't actually have to allow public participation. So there's a choice here. If you are allowing third parties to get party status, you're going to have a process for them to get access to the information and the rest of the procedures earlier. And that's probably going to require some changes for a lot of folks, because lots of times those people aren't getting access to materials or being able to submit evidence or all that kind of stuff ahead of time. For the rest of the world who aren't aggrieved or affected persons, I think that there's a political practical problem of making sure that neighborhood groups, all condominium associates, all the other kinds of people who are normally public participants and players in these kinds of hearings get more and better notice about how to play. If you've got a local government where the neighborhood associations automatically get notice of public hearings, I think somebody from the planning department or somebody should be contacting them and making sure that they not only are going to get these things, but they have some understanding about how they'll be able to, and their members will be able to participate electronically. I think that expectations need to be set about what that participation is going to be. Is it going to be that anybody can watch, but that if you want to speak, you're going to have to raise your hand or ask, flag it in some way so that you can be sworn in a jurisdiction that swears everybody, and then be queued up to be called on to participate and to have your 3 minutes. But I think there's a communication aspect of that that's got to go out. That's practical more than a due process issue. And so a lot of what I think this means is that the notice and the planning and the setup for a virtual quasi-judicial hearing is going to take more time and probably more steps than the in-person public hearings that we've been used to. And I think that's going to be true for hybrid hearings going forward. The governor's order relieved everybody of an interpretation of 286-011 that says to have a quorum, you had to hold a meeting, you had to have a majority of the board, of the total number of the board, physically in person and there. But AGOs have basically said as long as you had a quorum, other members could be virtually hooked in and that's historic. So it's really the EO only relieved everybody of the quorum requirement. I think local governments, while we're in a state of emergency, can do things with emergency orders to address a lot and fill this stuff in. Afterwards, they can adopt resolutions or other things to do a lot of this. It'll take a change in the law to eliminate the quorum requirement because it's an embedded interpretation going forward. But all of this is planning for the future too. So, and I think that third-party concerns, going back to where we started here, it all gets tied in. Depending on how organized those kinds of folks are in your community, if there are organizations to go to coordinate, do it. And get that open and long conversation started for the long run. If not, figure out ways to tag and invite people and to develop a blue ribbon group or a working group, including community members and other folks who can represent that and make sure that those kinds of concerns are out there. And I would also say that there's also going to be a class issue with here. There are still lots of people out in our world that don't have broadband. And so figuring out how to have participation centers with distancing and other kinds of things during the emergency anyway, in local community halls, other kinds of places in neighborhoods that people could congregate in less than groups of 10 and 6. I think all of that is important too. All of those things are important because there's a political legitimacy issue here as well as a due process issue. And it really won't be helpful over the long run to create virtual meeting systems or procedures that meet every statutory and constitutional requirement, but create such a political backlash among folks in the community that nobody's willing to support them or use them.
Thank you, Robert, and I appreciate it. I mean, there's so much to talk about. I would like to turn it over to Nikki Day for just her feedback, but before I do, I want to let all the attendees know that we are trying to answer the questions that are being posted as we're going. For that reason, we're running a little bit over, so we're not going to go directly to the Q&A. What we will do is, as we've been going through it, I am making sure to capture all of the questions that have been asked. And if it's something that we can answer after the fact, then of course we'll be willing to do that and happy to do so. But I just wanted to manage expectations as we have about 10 more minutes. After Nikki, I'm hoping we'll move on to our final thoughts from each of the panelists. And again, we appreciate everything, all of the questions coming in. Some of you are still raising your hands. If you have a question, please go ahead and submit it through the Q&A as I am capturing that information. And for now, I'll turn this back over to Nikki for your comment and response.
Real quick, I just wanted to add something to the comments that Mr. Lincoln just made with respect to interested parties. Be sure, practitioners, to also check the jurisdictions that you're operating in the 2nd District Court of Appeals, for example, that jurisdiction in Florida. What is reasonable for an interested party does not necessarily mean once that person is given party status that they are entitled to the exact same process as an applicant. The traditional standards of what is reasonable from a due process perspective apply and may depend on the interest of that interested party. And obviously that is potentially going to be very different from an applicant or an affected property owner or directly affected property owner. So just keep that in mind. Just because something, we see this play out traditionally in quasi-judicial hearings before COVID-19. The applicant may be given 15 or 20 minutes to speak or to close, and an interested party may be given 3. Those types of variations in the process given have been recognized. So be sure to check those in your jurisdiction too as you're navigating issues with regard to interested parties. And I just wanted to say one aspect about the executive order and the quorum requirements. First, there's been some question that it was not extended by Executive Order 112. The duration of that order is not defined, but I believe it statutorily defaults for the 60 days until it is modified. Second, there's been a question about whether or not the governor's executive order automatically suspends or gives the jurisdictions the ability to meet virtually. There is another CLE on this matter that I believe was recorded, maybe it wasn't, with regard to virtual meetings generally, but that may be a good resource for looking at some of those virtual meeting questions generally. But the answer to that question is it's also going to depend on where the specific quorum requirement is coming from. As Mr. Lincoln mentioned, the governor's order addresses state level quorum requirements or implication that a meeting will be held in a physical location. It does not address local requirements. So whether additional action needs to be taken by an individual local government is going to depend on where their quorum or physical location requirement is stemming from. Thank you for letting me add those two things, Jeanette, and I'm going to put myself back on mute.
That's great. Thank you, Nikki. And as Jeanette mentioned, we've received tons of questions. A lot of these are similar repeating questions, which really tells me that there are issues that need to be worked out. And as was mentioned by several of our panelists, that a lot of this is jurisdiction specific, and that the local ordinances are going to be a place that you have to turn. So I want to raise 3 topics that have been mentioned, but I'll ask the panelists to, we're going to go into your closing comments, but I just want to tee these up if you feel like addressing one of these. One is swearing in. We've talked about that, but there are a lot of questions about the logistics, mass swearing in rather than individually, and how that could be handled. So if that's something that could be included in your final comments. A second question was about submitting evidence, and that question has been repeated several times about submitting evidence ahead of time or at a meeting, or as rebuttal, maybe something that was not included, but as rebuttal evidence. And a third was similarly about cross-examination or responding to comments. So those are a few things that have been teed up, and I think that those questions again are going to be jurisdiction specific and have a lot to do with how quasi-judicial hearings have been run up until this point. So we have a few minutes left. I'll start with you, Patrick. Final thoughts?
Yeah, thanks, Robert. I appreciate you mentioning some of those questions. You know, one of the things that I wanted to kind of end with was to say that, you know, no pun intended, now is not the time to try to bulldoze a project through this process. We're all going through this kind of mess together and trying to figure it out. And so, you know, I don't think it's, you know, a great idea to try to strong arm your way through this. I think long term that's going to create some problems for you. But at the same time, I think it's completely justifiable to either point out some discrepancies or some problems, and more in response to your question, to raise the fact that you have a right as an applicant to cross-examine witnesses or to provide rebuttal evidence or rebuttal information. You know, ahead of time, the best way to do that, in my opinion, is to work with a local government staff and an attorney's office, general counsel's office, whatever it may be. But during a quasi-judicial hearing, you have every right to speak up and say, you know, I want to ask some questions here, or I have information that I need to submit. And how are we going to handle that? Are we going to delay this particular issue? It's not going to conclude at this particular meeting because there's not a mechanism to present evidence live, or is there, you know, a mechanism? But I would just caution kind of ramrodding your way through that process is probably going to end up creating long-term problems. And so to keep in mind that, again, we're all kind of going through this and trying to figure it out and doing the best we can, as you've heard. And while you want your project to get approved and you want to get out of the process, you've got to have that kind of holistic thing in mind that we're all trying to figure this out. But at the same time, don't be afraid to speak up and say, I see a problem here, or I've not been afforded an opportunity to do what I have the right to do.
Thank you. And Nikki, I'll turn to you. Final thoughts.
Thank you so much. I've had the opportunity last night to participate in a Zoom meeting with some of my leadership Tampa Bay classmates, and a lot of us hadn't seen one another since like 2015. And I'm sure a lot of people watching or participating in the CLE have had different similar opportunities to connect with colleagues, friends, or family during this time in a way that they may have never expected. Participating in this CLE is crazy to me. There's 3 different sections of the bar. We have 800 people here, and I'm broadcasting live from downtown historic my house in my remote garage. So it is, it's a privilege and an honor. I think it's a monument in the way that we've thought about connecting and sharing ideas for continuing legal education. I hope that this is one of the things that the Florida Bar takes and uses as a way to make, to present more opportunities for lawyers across sections and across practice areas to come together. While totally different in substance and structure from the quasi-judicial hearings and specific issues and considerations that we've discussed in this seminar, I think the second biggest takeaway is the increase and prevalence of remote and virtual communications is becoming more of a staple and more of an expectation, particularly for participating in what we would otherwise consider even mass types of communications. For many of our government clients, we've actually seen substantially increased numbers of participation in a number of the virtual meetings that have been conducted during this time of COVID-19. So I think if we simply expect that things will go entirely back to the way they were, including some of the things that maybe applicants have come to expect, such as, the element of surprise or the element of certain things that maybe have incorporated into practices or preferences before. If we insist on going back to only that model, we may be missing an opportunity to consider how these technological tools and resources may allow for continued increased participation and community involvement in these important decisions. So specifically, I think we're going to see some communities in these reopening phases begin to migrate toward in-person and virtual meeting, either hybrids or models that account for restrictions on movement and social distancing, but that still allow for those members of the public who wish to participate electronically to try to have the opportunity to do that. And I'll say, for all of the various logistics we've discussed today, and there are probably hundreds of questions that could stem from any individual platform on the logistics of some of these items. But for all the logistics that we've discussed today, there are even more presented when you begin to have certain hybrid models that may be one manner that parties expect that they can present testimony, particularly expert testimony, in future hearings. So as attorneys, I agree with what Patrick said. I think we have a unique opportunity to help our clients navigate these unique issues and work together during this time. And thank you to the Florida Bar and to all the sections for putting this together.
Great, thank you. And Erin, your final thoughts.
Yeah, I'll be brief because I think Patrick and Nikki both did a good job of sort of wrapping us up here. But I do want to echo a little bit of what Nikki said, which is I think this virtual environment that we're in is not going anywhere. We may get back to some semblance of normal, but we live in a state that just inherently has vulnerable populations and also transient populations. We have a lot of folks who don't reside in the state here full time, and the ability to participate remotely is it's not going anywhere because it does improve access for those citizens to be able to participate in their government and to have their interests heard. So I would just, in closing, say that while some of this is painful to be figuring out right now, I do think that in the long run, it is going to result in a much more effective, much more efficient process for both the public and private sectors. And I'm looking forward to continuing to work together as we figure out those issues. So thank you, guys.
Great, thank you. And Victoria, we'd like to hear your final thoughts. Thank you.
I think most of my final thoughts have to do with notice, oversharing, over giving information of that this meeting will take place, working very closely with your IT departments. If you are not ready to have this type of meeting, don't have it. That's my best advice to you. Working obviously with the other side to have as many agreed upon exhibits and having your witnesses available in different locations is also something that is very important to do to streamline these meetings. And after the pandemic is over, honestly looking into your processes and seeing how you can streamline a lot of the things that we've been doing in order to allow for more access virtually if possible. But obviously that'll take a few revisions in our state statutes as well. But thank you for this opportunity, and I'm available for any questions. Email me and we'll definitely put up items for you to review in the recorded version of this. Thank you.
Great, thank you. And to you, Mr. Lincoln, to wrap us up, your final thoughts.
We're going to be having effects from this pandemic for a long time. It's not going away by July. We're going to be dealing with things. We have a state where, if you look around, a lot of our elected officials are over 60. They're in threatened populations, will continue to be. So in the short run, in the medium run, this isn't going to go away, and we're going to be dealing with it. In the long run, due process is a flexible concept when we talk about quasi-judicial hearings. I don't think there are anything that I have been able to identify that's a due process barrier to making these kinds of hearings work now or in the future, whether it's purely virtual or hybrid or however. And I think that all of the different challenges that we are going to have to go through to make this work, they're all challenges that exist in the system today and actually have been creating problems for the system today and would in the future, and that we're only going to be identifying and addressing things that are existing problems as we make this kind of thing work. And I think that's going to be very important. I do want to say this, that outreach, all of these other kinds of things are critical, that if we look around, the haves versus have not problem about who has access, who has knowledge, who has the ability to participate, it's also going to be exacerbated and highlighted by these kinds of problems. And land use decisions aren't usually the ones that that identify and magnify these kinds of schisms in our communities, but sometimes they are, and they're there. And so trying to identify and fix those problems while we're doing all the rest of this is also, I think, going to be one of the bigger challenges, because the development community and the local governments and the other organized interests, they will work together. We will figure out how to make all this stuff work. It's the people who are unrepresented who are going to have problems, and I think that we're going to have to keep looking out for it as we go ahead.
Great, thank you. And I'd like to thank my co-moderator, Jeanette. I'd like to hear your final thoughts.
Well, I guess I'm going to take this in a little different direction. And for those who we still have on the line and then still watching and talking about looking forward, as a former IT professional, chief information officer, 20 years ago, I was teaching students in college online. Fast forward to this pandemic in 2020, fortunately, we have the technology. The technology was there that we were able to continue to conduct business. In the state of Florida, we're just so used to gearing up and preparing for a hurricane, something that's going to take 7 days and not 7 weeks. The technology being there, and I do have a lot of thanks to everyone out there who realized that the technology can be useful and it can be used, and that sometimes we have to get a little bit uncomfortable to make progress. And I think that's what's happening right now. I remember when the e-portal went in back in 2014, and I worked for the clerk of court at that time, and I was getting cursed out every which way sideways because it was such a new technology and people didn't know what to do with it. I think that's where we are today, and this pandemic is showing that we do have the ability to use the technology, and it can be beneficial and it can make us more innovative. We certainly have some barriers and hurdles to cross, but I appreciate everyone who's logging in and who's making this work in this environment. So those are my final thoughts, that I don't think we're done with it yet, and we have a little ways ahead of us to go, but the pandemic has showed us that we are able to rise and come together and work together on both sides, you know, whether you're an applicant or a city, and making this happen in an environment where for quite some time we were shelter at home. So thank you to everyone who has participated, and be sure to turn in your credits. And I really appreciate the opportunity to co-moderate this this webinar. Thank you so much.
Great. And thank you to all of our panelists, to all of you that joined us today. On behalf of the Environmental and Land Use Law section, the Real Property Probate and Tax Law section, and the City County Local Government section, as well as our friends over at the Florida chapter of the American Planning Association, we hope that you've enjoyed this seminar, and we look forward to continuing this conversation into the future. Thank you.